But look, the Law Society rules are fairly clear with respect to how you can market your law firm.
Hello and welcome to the next edition of Beneath the Law. My name is Gavin Ty, here with my good friend Stephen Teal. Stephen, how are you doing?
I'm doing well, Gavin. How are you doing?
Well, I am pretty good and glad I haven't suffered any personal injuries recently.
And why is that?
Well, because, it is become a real industry, the personal injury industry, if I can call it that, where I suppose, one's misfortune is another person's fortune. And that's certainly the situation with the personal injury bar in Canada, and I take it as a adjunct of what has always been or long been the case in the United States and other locations. But today we're going to talk about a kind of an interesting segue to all of this, because in the span of my career since when I started practicing law in the early 1990s to now, the whole perception of the bar, the plaintiff bar, and its ability to interact with the public has really, really changed. And just to give people a little bit of background, when I first started practicing law, lawyers' advertising was, first of all, seen as extremely poor taste. Lawyers, generally speaking, my impression was, were not particularly out there marketing and advertising. It was viewed as beneath the professional stature of the bar. And in fact, advertising was, if not improper or unlawful, was very, very highly regulated by the Law Society. The floodgates opened up quite a bit in the last 30 years. To now, we're at the point where it's pretty hard to flip on a news station without banner ads running along. And I would suggest that personal injury lawyers, I don't have the statistics on this, but they are a pretty big source of revenue for advertising in mainstream media. And every second bus that goes by has got some personal injury or other lawyer on it advertising.
And they're advertising great deals.
Well, they're
right? You don't pay unless you win.
Well, it's an interesting concept. Maybe I'm an old school thinker, but generally speaking, you're not paying for advertising unless there's money to be made. And the legal profession is, like many, many other professions, no different. And so if there is lots of money being spent on advertising, you better believe that there's lots of money being made on the other side of it. So one of the real, I'll call pioneers in that area, and certainly one of the big faces and someone who is extremely prolific in their advertising spend, is a lawyer named Jeremy Diamond. And Jeremy Diamond is one of the principals, I take it, in a firm called Diamond and Diamond. And if you live in Canada, or certainly if you live in Toronto or in Ontario, and you haven't heard of Diamond and Diamond, it'd be pretty difficult. You have not watched any mainstream media or looked at a billboard in some 20 years. They are literally everywhere, and in every milieu of media. Recently, the Law Society tribunal came down hard on Mr. Diamond in relation to some of these advertisements, and it was in respect of a number of the claims that would be made by Mr. Diamond in his advertising and about his firm, that he was a, quote, award-winning personal injury lawyer, or then he was, the people's choice, or all the number one law firm, or what have you. These sort of what we used to call touting of one's abilities. And the panel of the Law Society decided that while they weren't going to suspend Mr. Diamond, he wasn't going to be allowed to practice law for a few months. Raises an interesting question as to whether he was practicing law at all in the first place. And they also fined him $100,000, which I take it, given the size of his business, probably was a pittance. But it really was an interesting adjunct where the society got back into the game, if you will, in terms of regulating advertising and lawyers' self-proclamation of their merits to the public. What do you think of it?
Well, I think part of this relates back, Gavin, to the opening up of the fee structure to permit contingency fees. And that certainly was a boom to the personal injury bar, where they could now charge, 35% of the damages received as their legal fees. And, that started, I guess, lawyers looking to the United States, where there's lots of advertising all the time with respect to the personal injury bar, and starting advertising now. When you look at the past, all you could really do was hang out a shingle, right? And it would wave in the wind, outside your law office that you're a lawyer. And, my understanding is that basically the Law Society prohibited a lot of marketing, and that you weren't really allowed to advertise your services to the public. That changed. With respect to Mr. Diamond, as I read the Law Society's decision, now that was the last decision, was the penalty. There were a number of other decisions that were made. He seems to have, at some point in time, admitted that he breached the marketing rules of the Law Society, that he had engaged in misconduct in respect to those. He wanted to resile from that admission, and the Law Society tribunal did not permit him to do that. And then was basically advertising, that he had represented clients when apparently he didn't really represent clients. All he did was refer clients to either other lawyers within Diamond and Diamond or outside lawyers, and I guess he was getting a referral fee for that. But look, from a protection of the public standpoint, I think it's really important when people hold themselves out to the public and make certain claims that they're actually claims that have some substantial truth to them. There's obviously there's sometimes puffery in advertising, but when we're talking about a trusted profession like the practice of law that we're both in, he has to be careful. And, Diamond and Diamond, I think, is national now. 65 lawyers is my understanding from reading the decision. But that's pretty scary stuff. Yeah, I actually did some work for one of his competitors at one point in time when he was a sole practitioner, and he now advertises his law firm. But they're very careful, and you really need to use, one, the lawyers. You need to be accurate in terms of the awards that you've received. You can't basically compare yourself to other lawyers, and that was part of what Mr. Diamond had done, that he was top rated or the most trusted by whom, really reflects a comparison to that he's more trusted than somebody else.
So let's break that down a minute, because a couple of the things you've mentioned, I think are worth sort of noting. Again, I always start from the basic proposition that in the commercial world, no one is spending money on advertising unless they're making money on whatever they're selling. So let's go back to your point. So what we have here is a business model that's pretty straightforward. Lawyers can now charge what is referred to as a contingency fee. And for those who don't know what a contingency fee is, it's simply this, is that they get a percentage of whatever you get in terms of a damage claim. So let's say, sadly you were injured and you suffered a pretty serious injury. And as a result of that injury, a lawyer comes along and says, look, I got to take your case, and I'm going to take a percentage of whatever you get. So that you don't pay unless we win means that when I get a settlement and or we go to trial and I win and I get a judgment, you're going to pay me a piece of that. And as you pointed out, it's not an insignificant piece. It's 30, can be a third of whatever it is. So let's say if we were talking about it was $1 million is the value of the claim. And there are components to that are important for people to understand. Let's say that's $1 million claim, and therefore the lawyer would be entitled to $333,000 of that $1 million right off the top. So why I say that's important is if it's a personal injury claim in Canada, it's not a lottery ticket. Personal injury claims and settlements relate to a number of things. There's pain and suffering, obviously, as part of it, but there's often other parts of it. For example, generally there would be a loss of income. Somebody couldn't work for a period of time. Therefore, there's a component of that $1 million will relate to the wages that person lost as a result of the injury. There's also, in a large part, a present value of what's referred to as future care costs. So, for example, if somebody's really seriously injured, and they're going to need help in terms of their day-to-day living, and they're going to need live-in care, what have you, that is factored into it. And those are huge numbers. I mean, we're talking a young person who's injured, who may need future care costs for the next 40 or 50 years. So you can imagine why that would be a pretty big number in terms of financing that future care cost component down the road that has been a result of the injury. And when you take 33% out of the present value of that future care cost number, that's a pretty big deal. So let's break that down now to what the Law Society had said was the problem with the Diamond and Diamond model, at least at this, they identified it. And I raised the point of whether or not it's practicing law or not at all. I don't know the answer to that. But what was happening here was that the marketing of the firm was drawing in a lot of people, obviously were calling, who had suffered injuries and needed help. And what was basically happening with that was that these referral fees was that those cases were being sold, for lack of a better word, to other lawyers or law firms for a percentage of that. So basically for answering the phone and referring the lawyer, and I don't know what the percentage was, but some piece of that 35% was being divvied out to the Diamond firm just for referring it to a lawyer who was actually going to deal with the case. And you start to see where that could be a real problem for people who really need the money, frankly, in terms of a personal injury damage award.
Well, for sure. I mean, I don't want to dig too deeply into the facts that, without having read all of the decisions where all the facts would be contained. But I think, Gavin, look, the reality is, and I think we should mention this, that with respect to Mr. Diamond, the law firm Diamond and Diamond continues to advertise today. The complaint with respect to his marketing tactics were restricted to a period of time between, I think, 2013 and 2017. So a 4 or 5 year period when I think they were just actually growing the business. And, I guess after that time, perhaps the model changed somewhat or the messaging changed somewhat. But look, the Law Society rules are fairly clear with respect to how you can market your law firm. And, there are other lawyers who have done it before in terms of trying to come up with something new to build their business. Look, having a law practice is fairly competitive. There's lots of lawyers around. And, with respect to the personal injury bar, obviously they were trying to do something different. And look, he was offside. They were making a lot of money. What I guess strikes me about the case is the $100,000 penalty really a strong justification, or was it is it a slap on the wrist given the size of personal injury awards, or potentially the size of personal injury awards?
Well, not even the size of the personal injury rewards. It's the size of the referral fee that was obtained. And I think, in fairness, and I don't mean it's not my role here to disparage anyone, but the admission of Mr. Diamond was that he had marketed his services that could, quote, mislead, confuse, or deceive, and is not in the interests of the public. And that was, they didn't tell people that, oh, we'll be referring you out to another lawyer. And oh, by the way, there was also an admission that while he marketed himself as a, quote, expert personal injury litigation lawyer, he did not actually represent or provide legal services to anyone. What he in fact, I think his admission was, despite claiming to be an expert personal injury litigation lawyer, he had never actually conducted a trial. And he was not actually a personal injury litigator in the sense that he litigated matters personally. He was for all intents and purposes, he was referring this out, and that was the issue, was not disclosed in any of the advertisements. And in fact, the advertisements, I think anyone who's heard them would know, was the intention of those advertisements was to give people the impression that the firm was actually handling the matters for them, when that may or may not have been the case.
And I think as well, and it was also basically making representations that they received X amount in an award for a particular case, without basically providing a warning that, look, every case is decided on a factual basis, right? So different cases will lead to different awards. And basically, you can't advertise that, hey, we were able to get $1 million for this client, come to us, without giving that warning that your case may not be that $1 million case.
Yeah, and I mean, from a personal perspective, I do find the whole thing a little unseemly. And it's really because of this. I think that sophisticated litigants or people who are involved, who have, frequent dealings with the legal system, they're not the target market for this type of firm. People of that nature, sophisticated individuals, generally speaking, will get lawyers by way of referral or reputation within the bar, or whatever. They know who to go to. These are mass marketing programs that frankly target lay people who have very little or no interaction with the legal profession or the court system on a day-to-day basis. And frankly, if they are truly personally injured people who are suffering, are quite vulnerable, I would think, at that particular point in time. So there is, this is a vulnerable segment of the population that is susceptible to being misled. I mean, things, claims such as we are the, quote, most trusted law firm, or the top-rated law firm, those types of claims, they resonate with people who don't know any better, for lack of a better word. And I think that's where the Law Society was trying to protect that segment of the population, which, as I said, was by nature very vulnerable.
Well, you raise an interesting point with respect to the Law Society's goal to protect the public. But what I'm fascinated about with respect to the decision is that the Law Society prosecution had put in a joint submission with Mr. Diamond that his penalty should only be a reprimand and a fine. Right? The $100,000 fine was actually proposed by, my understanding, Mr. Diamond.
Yeah, the fine's not the problem.
Right. And
it was the quasi-suspension, I think, he took issue with, and I think we need to talk about that part of the case, because that's an important part of the case from a legal perspective.
Yeah, for sure, because it was either, it was a slap on the wrist in terms of the reprimand versus a I'm going to call it a limited suspension, but, the panel makes very clear that it's not a suspension. It's I don't know, it's a 3-month prohibition.
You can't work. Well, you can't practice law, which it comes back again to the point was it is running a marketing scheme, practicing law. I call it a marketing scheme. I'm probably going to get in trouble for that. But I mean, the notion of, if Mr. Diamond, as the panel found out, wasn't actually, in court litigating cases, I mean, it's not practicing law as, we often think of it, although the concept of practicing law is a pretty broad one these days.
But I guess he wasn't even representing the client anyway, that it was somebody else doing the work.
No, he's referring it out for
right. My understanding is he would basically review the, I guess, intake information with respect to the claim, and then deciding, okay, here I'm going to give it to somebody else. You got a valid claim, and then that was it. That was basically his role, and paying for the marketing of the business.
It's a call center.
Exactly right.
But the interesting part of the flip side of this, and while I may have my own opinions, all based on those facts of that whole situation, the other side of it though is quite interesting. You point out that there was a agreed plea deal, if I can call it that, between Mr. Diamond's lawyer and the prosecutor for the Law Society. They made a joint submission as to penalty, and Mr. Diamond, in reliance on that joint submission as to penalty, had made certain stipulations in terms of facts and admissions in terms of facts. And then and this happens all the time. Plea agreements happen all the time, and they are a very useful tool in terms of resolving both criminal cases and regulatory cases like this one. But the panel wasn't taking it. The panel said, nope, it's too light for this type of conduct. We need more. We're not agreeing to it. And it's important for our listeners to know that I think is the basic premise of the fact that Diamond has appealed this ruling, and it's on the basis that, well, wait a minute, I got snookered, if you will. I made these admissions and gave this agreed statement of facts. I only agreed to it because there was this joint submission on penalty, and then the rug got pulled out from under me, and the panel went and did something completely different. That's an interesting point. An interesting legal concept is how much discretion should a panel have and or a presiding justice have to go along with a plea deal that the prosecutor has agreed to?
Well, look, I mean, neither you nor I practice criminal law. And in the criminal field, my understanding in general is that there are plea bargains all the time, but a judge does retain a bit of a discretion to not accept that. In civil, there are certainly in class action lawsuits settlements that need to be approved by the court, and I think there are a few decisions where the courts have exercised their discretion to actually not approve the settlements in a class action lawsuit. So, I think a judge always retains a discretion. But as I read through the cases, and perhaps I don't understand this quite well, but my review of the decisions that were cited all seem to have suggested that where a lawyer engages in marketing that is in breach of the rules of conduct, which are very clear in terms of, advertising needs to be demonstrably accurate, that there were suspensions all the time.
Yeah, for sure.
And
there should be.
Right. And so my question would be, why as a prosecutor would you be recommending a simple reprimand? Now, Mr. Diamond was not a habitual breacher of the rules of professional conduct. This is the first time it's come up, and perhaps it's potentially novel in terms of the entire shift to personal injury lawyers advertising at the time because of changes with respect to the ability to charge contingency fees. But I found that fascinating from just the perspective of why would you recommend a reprimand and not recommend some form of suspension right from the outset. Now, I guess, as you say, recommending a reprimand certainly makes the prosecution easier with respect to getting an agreed statement of facts. May cost less, may make the process a lot easier for the Law Society to deal with the issue. But still, at the end of the day, when you compare with other decisions, a limited prohibition, or I'm going to call it still a suspension, because he's still required to adhere to a lawyer that is not allowed to practice for that 3-month period, and maybe that's the appeal too. That from Diamond and Diamond's perspective, obviously they had a lot of advertising in the works, and having him penalized by the Law Society would certainly impact the advertising contracts that his law firm would have had in terms of those representations. So that may also have been part and parcel behind the appeal to allow that advertising to not further breach Law Society marketing rules.
Yeah, I mean, I think, okay, look, in part of the in the interest of fairness and balance, let's just quickly say, I mean, we're talking about contingency fees here, and contingency fees, while they certainly can be quite a lucrative source of revenue for the legal profession, there are benefits to them from the public's perspective. They do enable access to justice. So, for example, people that couldn't afford to pay a lawyer on an hourly basis, it lets those people have access to the court system that they may or may not have had otherwise. And frankly, it lets a transfer of the risk of litigation. And let's be clear, litigation's all about risk. Every case, I'm fond of saying, there's a winner and a loser in every case, and 100% of the litigants walking in think they are going to win 100% of the time, and 50% of them are wrong 100% of the time. So there's always risk in litigation. So transferring costs and risk over to the law firms, there is commercial and a real societal good to that. So I wanted to say that right up front. In terms of the other issue, though, that you raised, which is the need to rely on plea agreements. So plea agreements are not necessarily a bad thing. Our court system is incredibly backed up. Our court system is collapsing under its own weight in terms of the amount of process that is required. Plea agreements are, for the most part, a short circuit, if you will, on what could be lengthy and expensive trials in a whole bunch of instances. That's the reasons why cases, are pled out or whatever. You mentioned settlements. Settlements sometimes require approval of the court. If all the parties, if nobody's under a disability in a regular civil lawsuit, if a party is under a disability, like they're a juvenile or they're incompetent or something like that, then you still will require a judge to approve the settlement. But people are pretty much free to enter into whatever deal they want to settle their disputes privately. In this type of an instance, though, there is a societal good to having plea agreements honored, because if people feel that the plea agreement reduces their risk, they can end it. It might encourage people to enter into plea deals and then save the system an enormous amount of time and money getting to what will be the inevitable conclusion in a given case. Whereas if people think that, well, I can agree to all of this, I have to basically fess up, for lack of a better word, enter into an agreed statement of facts, and then I got to still roll the dice on whether the outcome will be, favorable for me or not. That's a lot of people are going to back out of plea agreements and say, forget it. I'll just go to trial and take my chances because I'm taking my chances anyways.
For sure. Look, from the opposite perspective, I think there's a lot of merit to basically suggest or argue that at the end of the day, the panel of the Law Society got it right in terms of protecting the public from marketing tactics that were offside our rules of professional conduct, and that a reprimand would have sent the wrong signal to the profession that they can basically be scofflaw, have their advertising basically be scofflaw or offside the rules of professional conduct, because it would become a significant precedent for others to say, well, I shouldn't be suspended because, I made a misstatement in the advertising. It wasn't so bad. I didn't make a lot of financial gain from it. I mean, in Mr. Diamond's case, they made a lot of financial gain. And I think that was probably the linchpin of why the panel refused to actually accept the joint submission on penalty. He was making a lot of money, and so a reprimand was not the appropriate penalty. So there are certainly people who would support that from a protection of the public perspective.
Yeah, we're out of time on this very interesting topic, or actually two interesting topics. Before we go, we practice law, and I just encourage people. One of the things that, careful of grandiose statements of I'm the greatest, or I'm the best, from alleged rating agencies, and always try to think about follow the money, and who's making money here and who's not. And it's true for everything, every aspect of society, and the law is no exception. So this is certainly I think a cautionary tale in some instances for people to understand that there's a lot of money that passes hands in the legal profession, and it is a profession of trust, and you have to be very careful sometimes what the real deal is in terms of the arrangement. And I think that's what the Law Society was really getting at, is that the client has the right to know and the right to have their informed consent as to the terms of the retainer of any lawyer. And this is no different. So for Stephen, I think that's about all we can really say on this topic for today. But listen, I wanted to say to our listeners, thank you so much for listening to us and giving us your valuable time, and hope that you enjoy these podcasts. If you do, please rate us on whatever service you're using. We really appreciate any rating we have. Any feedback you have, please get in touch with us. We're more than interested to hear any comments, concerns, ideas for future episodes. There's so much to talk about that's happening in the courts and in society on a daily basis. And we certainly have no shortage of topics, but there's no doubt that some topics are more interesting than others. I'd be pleased to hear from you and your thoughts on that. So, Stephen, with that, I'll end with our usual tagline, which is to say that if no one is above the law, then everyone is beneath it. Thanks again for listening, and hope to hear you and share some more thoughts with you again in our next episode.